Okay, well, I am live right now. Welcome, everyone. Thank you very much for joining me. My name is Lior Samfiru. I'm the employment lawyer, and you are here watching and listening in order to learn about employment law. So, for those that don't know me, again, my name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. We are the largest employee side firm in Canada. We operate in Ontario, in BC, and in Alberta. And I am here as I am every week to talk about employment law, but mainly to answer your questions. This is a live Q&A session, the purpose of which is to make sure that you have answers to whatever issues, questions, or concerns are bothering you when it comes to workplace rights. You may have questions because of your vaccine status and losing your job because of that. You may have questions about your severance package. Maybe you're not being treated properly by your boss. Maybe your compensation, your hours, your responsibilities have changed. Can they do that? Maybe your business is being sold and you want to know what to do in that situation. Whatever the issue, whatever the problem, there are answers, there are solutions, there are things that you can do, and the law is on your side. I oftentimes hear people saying the law is not on our side. That's nonsense. People that say that don't understand what the laws are like in Canada. Employment laws are some of the best laws in the world in terms of rights of employees. So take advantage of me being here. Ask your questions. Make sure that when we're done here in about 30 minutes, you've had those questions answered. You can look forward to having a better week because you know what to do. You know what to say to your employer if that's the situation. So again, my name is Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. And before we get started, let me give you some other contact information. If you want to connect with me privately by phone, by email, or with my team, we have a huge team across Ontario, over 40 people, and across Canada, I should say, not just Ontario, across Ontario, BC, and Alberta. Here's what you do. You just go to employmentlawyer.ca. You see that address below on the screen, employmentlawyer.ca. Okay, and that is our website. And you can find out information about employment law there. You can get the contact information, email addresses, phone numbers, forms, if that's what you prefer. So your number one resource to connect with me, for me and my team to roll up our sleeves and get to work, is employmentlawyer.ca. Again, employmentlawyer.ca. So with that said, I'm going to start answering questions right now. Ask them now. Don't wait till the end of the sessions because we always get questions right at the end, and I may not be able to get to them if you ask right at the end, and you'll leave without an answer. So ask them right now, guys. I'm live. I'm Lior Samfiru. I'm answering your questions about employment law. First question from Ellie. I'm on a commission-based salary. How are short-term and long-term disability payments calculated? It's simply going to be an average. The policy is going to outline what an average is. Usually, it's a one-year average. So it's based on your income, say in the last year. That's going to be an average, and that's what's going to be used to calculate your disability payments. Your insurance policy may stipulate a different time, maybe 6 months, maybe longer. But it's going to be an average. So it's going to be, you're not going to be penalized because you're on commission. So we're going to look at your average commissions, and that's going to be the amount. And remember, if you're ever in a situation where your insurance company is not approving you or approving you for a short period of time or approves you and then cuts you off, that's wrong. They should be doing what your doctor is saying. So if you find yourself in a situation where the insurance company, your disability insurance company, is not doing what it's supposed to, give me a call or send me an email. We have a whole team at the office just dealing with these issues. They're unbelievably good, and their job is to get the insurance company to do what it's supposed to do. So again, to connect with me on that issue or any issue, employmentlawyer.ca. Thank you for that question, Ellie. Next question on YouTube from Freedom Thedden. Probably mispronounced it. My apologies. What if an employer bullies, manipulates job performance duties to make employee look bad, then denies breaks or lunch in the U.S.? So I can't answer you anything in the U.S. None of what we talk about applies in the U.S. Whatever the law is in Canada is going to be very different. So you can't get any help in the U.S. on this session. What I can tell you in Canada, and that doesn't apply to U.S., if you can establish that your boss is putting you down, mistreats you, bullies you, that could be a constructive dismissal. You could treat that as a termination of employment. That is only in Canada, has nothing to do with the US, okay? So none of what you hear today applies in the US at all. All right, next question from iMountain Media. Okay. This is on YouTube. Do I have a case to sue my employer for segregation? They want to segregate a few of us in the unvaxxed corner of the office. There's no such thing as segregation from a legal standpoint. It would simply be if they create a situation that's embarrassing or uncomfortable for you, that could be, as I said before, a constructive dismissal. If what they've done makes it difficult to continue working, then yeah, that may be a constructive dismissal. So it's a question of how big a deal is it. In other words, if you're confined to a corner, what does that mean? You can't leave that office. It means you're on top of each other. It means that it's embarrassing. So depending on the answer to those questions, that may be illegal, which means you could potentially treat that as a termination. But if it's not a big deal, you're moving 3 feet from where you were before and it's kind of okay, then it may not be an issue. So it's not about putting you in the corner of the office. It's about how bad is it? How does it affect you? That is really the issue here. And on that basis, that could be a constructive dismissal. So if you want to chat about that, by all means, employmentlawyer.ca to connect with me. All right. So let's see. From next question is from Lorna. I was laid off May the 6th, 2022 because they can't accommodate my restrictions. So, well, the first question is this. The first question is, can they accommodate, but are they choosing not to? What I mean by that is very often companies say, oh, no, we just can't accommodate. The restrictions are too much. Well, the real question is, can they do it if they want to, but they're choosing not to? Keep in mind, an employer has to accommodate even if it's difficult. Okay, it's not good enough for them to say, well, that's kind of hard to do, so we're not going to do it. So right off the bat, I do want to understand more about the company, how big they are, what kind of, first of all, what your restrictions are, and what kind of availability and other options does the company have. Beyond that, that could be an issue of severance. If you lose your job now, you're going to be owed severance. And again, I don't know how long you've worked there and your job, etc., but you're owed severance. So number one, this could be a human rights issue if they are not accommodating when they're supposed to. Number two, it's a severance issue. So you should contact me, Lorna, as soon as possible. Again, employmentlawyer.ca, so we can have a chat. I can get some more details, and I can help you make sure that you get everything that you should be getting. One of the things I could do is essentially force the company to accommodate you if that is possible. So again, employmentlawyer.ca, Lorna, to connect with me. For those joining us right now, welcome. My name is Lior Samfiru. I am the employment lawyer with Samfiru, Tumarkin, LLP. Why am I here? Well, as you see, I'm here live answering your employment law questions. I'm here telling you what you need to know about your workplace rights. We're getting lots of great questions. I'm going to continue answering them right now. If you haven't asked your question yet, what are you waiting for? Ask it right now. Write it in, type enter. I'll see it and I'll answer it. All right, next question then comes to us from Guy on YouTube. My employment contract reads that I'm entitled to 2 weeks of vacation after probation. My employer only paid me prorated bonus since my employment is less than a year. Is this compliant with the ESA? Yes, it is. So vacation and bonus, I'm not sure why you mentioned vacation because it really one has nothing to do with the other. So they should be paying you, 20% bonus a year, and in the first year you only work 8 months of the year, then they can pay you 8/12 of the bonus, a prorated portion of the bonus. That is absolutely fine to do. Nothing wrong there. Jacob asked a very long question. Jacob, I'm not going to be able to read something that long on this session. So if you can make it much shorter, 1 or 2 lines, then I can read it and answer it. Otherwise, Jacob, contact me at employmentlawyer.ca and we can have a private chat. I'm just not going to be able to read it in this session. Next question on YouTube from Natasha. Can my employer cancel my benefits while I'm off on medical leave? Well, so cancel. Take a step back. What they can do is not continue your benefits if you're on medical leave. If they continued your benefits, they're not necessarily then allowed to say, we've changed our mind, now we're cutting you off. So they could decide to say, if you're going to go on leave, we're not going to continue benefits. They could do that. Not fair, not nice, but they can do that. What they can do is continue your benefits and then one day wake up and say, well, now we've decided to cut you off. That could be a constructive dismissal. The reason an employer doesn't have to continue benefits if you're on a leave is because benefits is a form of compensation, right? Just like they don't have to pay you salary while you're not working, they don't have to continue benefits. But if they choose to do it anyway, they can't just change their mind and cut you off. Okay? If they did cut you off, like I said, then Natasha, call me. We can talk about constructive dismissal. Maybe I can even get them to change their mind. And you can contact me through employmentlawyer.ca. Ellie asks, could an average of 5 years be used instead of 1 year? So Ellie is referring to average income in a situation where she's on commission with respect to her disability. Well, we'd have to see your insurance plan, your insurance policy. I can't answer that without seeing your insurance policy. If you want to contact me, happy to take a look at your insurance policy. All right. Jacob, yeah, you can retype your message if you want and make it shorter so I can read it. Bill, again, you have a very long message there. I'm not going to be able to read that on this session, Bill. Make it shorter so I can read it. I'm just not going to be able to sit and read several paragraphs on this session. If you can't make it shorter and ask your question now, easy. Just contact me through employmentlawyer.ca. Again, employmentlawyer.ca. You can send me an email or call me and we'll have that chat. So let's see. Next question from Cheeseburger on YouTube. Best lawyer in Canada, Stan Fainzelberg, is a rock star as well. Well, thank you very much. Stan is one of our partners at the firm. Amazing guy, amazing team that we have. So Cheeseburger, thank you very much for that comment. Very kind of you. Appreciate that. Guys, we see how easy it is. I'm live. Ask your question. Get your answers. Make sure that you know what to do if you're in a workplace situation. All right. I think Jacob tried to make his question shorter. Let's see. My employer made us work from home during the pandemic. My employer started this winter making all management work from site and let advisors come back to site if they wanted to. My employer is now coercing everyone to be permanent work at home since they're losing their long-term office space and are making it as that's what the majority of staff wants. I'm not sure I understand here. Not the best written thing. I think what you're saying is that they're telling you from now on you have to work from home permanently. They did that over the pandemic, and now they're saying that you have to do it permanently. If that is what they're doing, they're not allowed actually to do that necessarily. That could be a constructive dismissal. So now, if I've understood your situation correctly, Jacob, here's the options. Option number one is you can treat that as so you can accept it and do what they want and work remotely. That's fine. Option number two is you can treat that as a termination of your employment and require them to pay you severance. That's what a constructive dismissal is. Based on your age or position, the length of your employment, you're going to be owed an amount of severance. That could be as much as 24 months pay. So those are the options. Do what the employer wants or treat that as a constructive dismissal. If I misunderstood the question, let me know, Jacob, okay? Thank you for that. Pablo has the next question on Facebook. I have a fixed term contract for 3 years, but I don't have the resources to work. They want me to quit. What would happen if I quit, or should I wait for them to terminate my contract? I'm not sure I understand what you mean by I don't have the resources to work. I don't know if you mean that you simply can't do the job. If you can't do the job, then I guess you can't work and you've resigned just by not working. So I'm not sure exactly I understand. Keep in mind with the fixed term contract, if they let you go, they have to pay you the balance of the contract. So that could mean paying you for another 2 or 3 years. So I need to understand what you mean when you say I don't have the resources to work. Is it just that you don't have the tools, or what is it? All right. Next question on Facebook comes from Leah. I have worked at my child care center for 33 years. It is governed by a nonprofit society. 5 years ago, a corporate manager was hired. Over 18 months ago, I started writing letters about his harassing conduct and bad management decisions. The board has attempted to not look at the problem. Now licensing has been contacted since May. The board suspended me with pay. The union is not much help. Unfortunately, if you're part of a union, there's nothing that you can do other than do what the union says. That's the problem with being part of a union, is the union decides what to do. The union has the rights, not the employee. And everything we talk about, by the way, on this session, or if you see me on TV or hear me on radio, everything I talk about only applies to non-union employees. It does not apply to unionized employees. Everything I say does not apply to unionized employees. The only thing you can do is work with the union, maybe threaten them that you're going to file a complaint against them, but that's the only thing that you can do in a unionized situation. Okay, Natasha has the next question on YouTube. What is the period of time an employee can be away from work before an employer can claim frustration of contract? Great question. So frustration of contract happens when an employee's been gone for so long that the employer can simply say employment has ended. So there's two things that have to happen for frustration of contract. Number one, a long absence. I'll talk about that more in a second. But number two, and just as important, is there has to be evidence that it's not likely that the employee is going to be able to get better to come back to work. Usually we'd be looking at an absence of about 2 years or longer, but that's not enough. The employer would also have to show that the doctor is saying that this employee is not likely to be able to come back to work. If it's been 2 or 3 years and the employee is still working on trying to get better, it's not a frustration of contract. Okay, so two things: long absence, usually 2 years or more, and no likelihood of return. In those situations, the employer can say frustration of contract. Now, if you're in Ontario, if it's a frustration of contract situation, you're still owed severance. Not your full severance, your minimum severance, but still owed severance. In BC and Alberta, on a frustration of contract, there would be no severance owed. Okay. Pablo says, yeah, I don't have the equipment. Well, then, why don't you have the equipment? Did you have it and lose it? Did it break? Did the company take the equipment away? Right? I need to understand that. They hired you to do the job and you never had the equipment. Did you ever actually work? Right? I need to understand those situations. Guys, for those joining me, welcome. I'm Lior Samfiru. I'm the employment lawyer, and I'm answering questions live. Ask your questions. Lots of questions coming in still. Love it. So please ask your questions. You still have some time. On YouTube, the next question is from Guy. How much vacation is owed upon termination? Do employees earn full 2 weeks of vacation upon termination if the employment agreement says so, or is the vacation prorated based on when a termination occurs? So the employee is owed the vacation that they've accrued up to the last day of termination. So whether it's 2 weeks, 3 weeks, 10 weeks, whatever was accrued up to the date of termination, that's the vacation that the employee has to get paid. So you may have had zero vacation. You may have taken already all the vacation and maybe nothing owed. So whatever vacation was accrued to the date of termination, that's what the employer has to pay. All right, let's see. Jacob has a follow-up question. My employment contract is also very broad and says I cannot treat anything as constructive dismissal. I'm considering treating this as a constructive dismissal. Can we do this? Well, I haven't seen your employment agreement. It's not likely that it would prevent you. So yes, you need to contact me in my office so we can talk about constructive dismissal and whether your situation is that. But again, I'm not going to speak to you about your employment agreement if I haven't seen it. Let's see. Next question is from Tammy. Tammy's on Facebook, and she says, I was laid off and not hired back for no reason. I was ready, willing, and able. Instead, they hired people on an immigration program. What can I do? So the fact that they didn't bring you back in and of itself is not legal. It's a crappy thing to do, and it's not good, but it's not illegal. What this is about what is the compensation that you're owed, the amount of severance that you are owed. So they have to pay you severance. They can't keep you off work. They have to pay you severance. In fact, they didn't have even the right to put you on the layoff, right? So they have to pay you severance. So for you, Tammy, and for everyone else, here's how you can find out right now, how much severance is owed to you, whether it's a layoff, a termination, a constructive dismissal. Here's how you find out what is owed to you. All you do, you see that address already below me. You go to pocketemploymentlawyer.ca. I'll give that again. It's pocketemploymentlawyer.ca. When you go there, you'll see our severance calculator tool. Severance calculator, that's what it does. It calculates severance and it tells you how much you're owed. You can use that. It takes seconds. It's completely free. It's completely anonymous. You don't have to put in your name. You don't have to put in the company's name, your address, none of that. Okay, so you go to pocketemploymentlawyer.ca, use the severance calculator, and find out again in seconds if you're owed 6 months severance, 20 months severance, 26 months severance, whatever that is. You can check it out at pocketemploymentlawyer.ca. So if you've lost your job, the very first place you go to is that pocketemploymentlawyer.ca. You grab your smartphone, your tablet, whatever you want, and you go there. If you think you've been constructively dismissed and you want to know what you'd be owed, again, pocketemploymentlawyer.ca. Over 2 million people have used it already. It works. It's great. So it's right there for you. All right. Let's see. Next question from Rocket. Do employers tend to learn from their mistakes after mistreating an employee when they are contacted by a lawyer, or do they tend to reoffend again? Well, I mean, I don't know that you can make a general statement. Some employers deal with it one way, others deal with it differently. Sometimes the people within the company have changed, so they don't have the experience. So really, there's no general answer there. And oftentimes it's not when they reoffend, they may be out of ignorance. They might not necessarily know that they've done something wrong. And so there's, every situation is definitely different. Next question is from Ewan Miranda on Facebook, or June Miranda. I've been on a temporary layoff. Do I qualify to get severance pay? As long as you're not part of a union, the answer is absolutely yes. An employer does not have a right to put you on a temporary layoff. You can treat the temporary layoff as a termination of employment and get severance. And it's as simple as that. So if you've been put on a layoff, you're sitting at home wondering what to do, 2 options, right? You can wait and see what happens, okay? Or you can choose to look at that layoff and consider that layoff to be a termination and require the company, make the company pay you severance. To do that, you're going to need some help from us, right? So if that's what you want, June, if you want to help, or if you need help getting your severance, and you will need help if that's what you want to do to get severance, contact me and my team to do that. Easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. Okay, Jacob says, I reached out to your office when this was announced a few weeks back. I will reach out back in mid-September if I need to, since my employer is trying to accommodate me now. Okay, sounds good. So if you need our help, Jacob or anyone else, you know what to do. On this session, I can answer questions, right? I can give you some thoughts. I can explain the law. But what I can't do is I can't get you something. I can't make your employer do something. To get me to do that, you have to reach me in the office or reach my team in the office. I've told you how to do that. Easy. Employmentlawyer.ca. Again, employmentlawyer.ca. All right, guys, still a few questions or a few minutes to go. So please ask your questions. Don't be bashful. Don't be afraid to ask the questions. You'll never get an answer if you don't ask the question. I'm Lior Samfiru, the employment lawyer. I'm answering questions. I'm going to continue doing that right now. All right, next question is from Guy on YouTube. For employees work in sales role, not sure what you mean, can the employer make the bonus discretionary and withhold the bonus based on their discretion, even if bonus is earned based on achieved sale targets? Well, if you have an employment agreement that says the bonus is discretionary, and the bonus has always been discretionary, sometimes you get it, sometimes you don't, then it's discretionary. But if you've always gotten a bonus, your employer can't then decide to say, well, now we've decided to change that. Now we've decided to make it discretionary. So if you always get a bonus that's, 20% based of your targets, your employer can't say, well, in 2022, it's not going to be that way. It's going to be discretionary. We're going to decide what to do with it. So number one, it's a question of what does your employment agreement say. And number two, it's a question of what has the company done in the past. They can set the rules at the beginning, but they can't change the rules, right? So very important to understand that. If you have any questions, Guy, before you agree to something, before you sign off on something, you got to reach out to me, okay? They may want you to sign a document that says that you've agreed to this new bonus terms. Don't do that, ever. Not without talking to me. To reach me, again, employmentlawyer.ca. Again, employmentlawyer.ca. All right. Next question is from Neha on Facebook. My position as an HR manager was phased out due to financial restructuring. I was given 4 weeks working notice that coincided with my 3-week approved vacation. I was paid no severance. Well, then you know what to do. It's easy, right? You contact my office. Let's make sure you get severance. Again, I don't know how long you've worked there, Neha. I don't know how old you are. The big factors are your age, your position, and the length of your employment. So I know you're in HR. I don't know how long you've worked, and I don't know your age. But you could be owed 10 months severance, 12 months severance. So if they haven't paid it, that's a wrongful dismissal. So Neha, you need to reach out to me as soon as possible. Okay, I wouldn't wait on this. Definitely don't sign anything. To reach me, employmentlawyer.ca. Again, employmentlawyer.ca. We have about 5 minutes left, so ask your questions. I think I'm caught up on the questions, so ask some questions there. Okay, so Neha says that I worked there for a year and my age is 36. So you're probably owed right around 3, maybe as much as 4 months of severance. 3 months of severance, as much as 4. So now the 4 weeks working notice that they gave you counts towards your severance. So if you're owed 3 months severance and they give you 1 month's notice, then they still owe you another 2 months that they have to give you by way of severance. Okay, so that's what you're owed. So you got to reach me as soon as possible. Again, employmentlawyer.ca and employmentlawyer.ca. Again, I'm caught up, I think. Ask your question, though, last couple minutes. Now, I mentioned pocketemploymentlawyer.ca. I told you that you can find the severance calculator there, but there's other things that you can do there. We have a tool that allows you to find out if you've been constructively dismissed. Okay, we have a tool that allows you to find out if your case is a human rights violation, if your rights under human rights have been violated. A tool to determine if your case is considered harassment. If you're let go for cause and you want to know, did the company have cause to let me go? We have a tool that allows you to do that. So that's why we call it Pocket Employment Lawyer, because it's a tool that it's like having your own lawyer in your pocket, on your smartphone, your tablet, what have you. A tablet may be a bit big to put in your pocket, but I think you get the idea. So if you have a legal issue, good place to start always is pocketemploymentlawyer.ca. We took the main issues that I deal with and we try to use technology to give you answers, to do an initial analysis of your situation. That's why you want to go to pocketemploymentlawyer.ca. And of course, the number one used tool there is the severance calculator. Speaking of which, Jacob says that the Pocket Employment Lawyer says I am entitled to $6,000 to $10,000 severance. How much of that would you take as payment for services rendered? Again, I don't know anything yet about your situation. We'd have to talk about your matter. It could be that you're owed much more. It could be that you're owed not as much. So when we do our consultation, we'll be able to assess that. Next question is from Guy. Can employers contract employees out of overtime if the job requires employees to work beyond regular hours to get the job done? No. Unless you have a position that's exempt from overtime, overtime has to be paid and you can't contract out of it. So for example, managers are exempt. So if you're a manager, then they can contract out of overtime. IT professionals, lawyers, doctors, for example, those people are exempt from overtime. But if your position is not exempt, they can't contract out of it. Okay, so that means you're owed severance. That means you're owed overtime. Okay, next question from Victor on YouTube. My employer is asking for my CPP disability application even after they have told me that my employment with them had ended. Is it legal for them to ask me for my disability? Well, if they're asking you for something when you're not working there, then no, they can't. But forget about that. The question is, if your employment has ended, we need to make sure you got what you're owed, right? That's the issue here. I mean, the disability, you just tell them to jump in the lake if you're not working for them anymore. Your insurance company, if you're getting disability benefits, the insurance company can ask for that, but not the employer. Now, but the real question there, Victor, is your severance, whatever you're owed as a result of losing your job. That's what you need to contact me for. Last question for the day on YouTube. Can an employer, this is from Teresa, can an employer decline a religious exemption request from the COVID shot twice? First request was declined. Well, again, if I haven't seen the religious exemption letter, I can't say, what was it for? Who was it from? Was it from your neighbor or was it from a priest? And what did it say exactly? If it's legitimate, no, they can't decline. It's illegal, but I'd have to see it in order to be able to say. Teresa, so contact me through employmentlawyer.ca. Be happy to chat with you and look at your letter and give you my thoughts and opinion on that. Guys, that's the time that we have for today. My God, what a lot of questions we got today. It felt like we went really fast because I wanted to get through all the questions. Thank you so much for joining me. It was a real pleasure. My name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. I'm looking forward to continuing this discussion with you privately if you want to do that. Again, employmentlawyer.ca. I'll be back next week, but don't wait for that. Let's connect, okay? Employmentlawyer.ca. Thank you so much for joining me. We'll talk to you soon. Bye-bye.